6 documents decide whether your children walk into a paid-off house the week after you die or spend the next 2 years watching it drain to nothing in probate court. Most seniors have only one of the 6. Some have none. And the ones who have all 6 are not the wealthiest retirees. They are simply the ones who sat down with an elder law attorney before age 65 and paid between $1,500 and $4,000 to get every single one on file. The 6th document is the one almost nobody files. It is not a deed, it is not a trust. It is a 1-page sworn statement, and without it, every other document on this list can still fail. Here are all 6. Document 1. The Lady Bird Deed. You sign a document that says the house belongs to your children the moment you die, but you keep every right you have today. Sell it, mortgage it, refinance it, or revoke it entirely without telling anyone. Nothing changes while you are alive. The second you pass, the house transfers directly to the children outside probate, and in the states that recognize it, outside Medicaid estate recovery as well. That second part is why this deed exists. Nursing home care in 2026 exceeds $100,000 per year. Without this deed, the state can file a recovery claim against your estate to recoup every dollar Medicaid paid for your care. The Lady Bird Deed moves the home outside the probate estate so the state cannot touch it. The catch: it only works in 5 states: Florida, Texas, Michigan, Vermont, and West Virginia. Cost to prepare and record: between $300 and $800. Failure cost without it, when a parent needed 18 months of nursing home care, commonly exceeds $150,000 in state recovery claims. If you live in one of the 5 states, this is your first call. If not, move to Document 2. Document 2. The Transfer on Death Deed. For the other 45 states, this is the floor document. Available in roughly 30 states, it works the same way. You name a beneficiary, the property transfers at death outside probate, and you keep full control during your lifetime. Cost: between $150 and $500. Skipping this document in a state like Ohio means a probate process averaging 8 to 14 months and attorney fees between $3,000 and $8,000. One warning: this deed does not automatically protect against Medicaid estate recovery in every state. In some states, the protection is complete, in others, it is not. Verify with a local elder law attorney before relying on it as your only protection. Document 3. The Revocable Living Trust. This is the universal answer. A revocable living trust is a legal container you create and fund while alive. You are the trustee. A successor trustee, usually an adult child, steps in at your death. The house bypasses probate in every state, and the successor trustee has immediate authority to sell or distribute the home without court approval. But here is where 70% of trust plans quietly fail. The attorney prepares the document, the senior signs it. Everyone assumes the home is protected. But the home was never redeeded into the trust. When the senior dies, the home goes through probate anyway, because it was still titled in the senior's name. A trust without a funded deed is a filing cabinet full of paperwork that does nothing. Cost for a complete package, including the quitclaim deed, pour-over will, and powers of attorney, between $1,500 and $3,500. The probate it replaces on a $380,000 home commonly costs between $9,000 and $18,000 and takes over a year to close. Document 4. The Senior Homestead Exemption. This one protects the value of the home while you are still living in it. Available in Texas, Illinois, Florida, New Jersey, Georgia, and roughly 30 other states, once you turn 65, you file a 1-page affidavit with the county assessor, and your property tax assessment is frozen at its current value. In Texas, a homeowner who files its 65 locks in their school district tax assessment at that year's value, forever. On a home that appreciates from $250,000 to $600,000, that single affidavit saves between $3,000 and $5,000 per year. Over 15 years, the failure cost exceeds $40,000. The county does not send a reminder. You have to file it yourself the year you turn 65. File it late, and you cannot claim the prior years back. Document 5. The Irrevocable Medicaid Asset Protection Trust. This protects the home from nursing home costs in states where the Lady Bird deed does not work. Once the home is transferred into this trust, you cannot take it back, but you retain the right to live in it for the rest of your life. Medicaid no longer counts the home as your asset, provided the transfer happened more than 5 years before you apply for long-term care benefits. That 5-year window is everything. Any transfer inside the look-back window is penalized with a period of ineligibility. After 5 years, the home is fully protected and Medicaid covers the care. Cost to establish, between $3,500 and $6,000. Without it, a senior needing 3 years of nursing home care at over $115,000 per year can lose the full value of their home. With it properly funded 5 years earlier, the home passes to the children and Medicaid pays the bills. This is why elder law attorneys recommend this conversation in your early 60s, not your late 70s. Document 6. The Certification of Trust. This is the one almost nobody files, and it is the document that decides whether everything else actually works. You establish a trust. You have the home deeded into it. You name your daughter as successor trustee. You die. She walks into the bank and says she is the trustee. The bank says prove it. Without a certification of trust on file, she has one option. Take the full trust document into court, file a petition, attend hearings, and get a judge to confirm her authority. That process costs between $2,000 and $6,000 and takes 3 to 9 months. During those months, the house cannot be sold, the mortgage still has to be paid, and the estate bleeds cash every single month. With a certification of trust already recorded, she hands over a 2-page document. The title company verifies a few details. The transaction closes the same week. Cost, typically bundled into the original trust package. If not included, between $200 and $500 to add later. Recording fee, between $15 and $50. The action plan. Start with the Lady Bird deed if you live in Florida, Texas, Michigan, Vermont, or West Virginia. Transfer on death deed if your state recognizes it. Add a revocable living trust if your estate includes anything beyond the home. File the senior homestead exemption the year you turn 65. Start the irrevocable Medicaid trust conversation in your early 60s while the 5-year clock can still work in your favor. And confirm every trust has a matching certification of trust on file with the county. One consultation with a qualified elder law attorney, typically between $150 and $400, covers all 6. Bring your deed, your property tax assessment, and your adult children's names. 1 appointment, every gap closed. 6 documents, between $1,500 and $4,000 total to get them right. The cost of getting it wrong, probate fees, nursing home bills, forced sales, can exceed the entire value of the home. The families who lose the house are almost never the ones who could not afford to protect it. They are the ones who never knew these documents existed until it was too late. Now you know. Schedule that appointment before any of these windows close permanently. If this video helped you or someone you care about, hit that like button and share it. This information needs to reach more families before it becomes their problem. Subscribe and turn on notifications so you never miss the videos that could protect everything you have spent a lifetime building.